So when you're talking about Regulation D, that's the first sort of key word, Regulation D. That's what you should walk out here with, just have some understanding of. It's comprised of really 6 numbered sections, a variety of different rules, rules 501 through 506, and when you're really talking about particular exemptions and where you fit in, there's really 3 that you should be concerned about that I'm just going to touch on here to give you some idea about. That's Rule 504, 505, and 506. Okay? Again, these give you the basic guidelines for offers and sales of securities in the United States on a private placement level. So, when you're talking about Rule 504, you can basically walk away with this key thought that it really governs offerings of no more than $1 million in securities in any consecutive 12-month period. And what's important, that it's unlike any of the other rules, it does not impose any specific disclosure requirements. And by disclosure requirements, I mean, and I'll get into it in a little more detail, it's providing all the information that a reasonable investor would want to know. You know, if you're a mom and pop organization and you're about to buy some securities from some organization, from some company, you really have the obligation to tell them what the risks are, what the security involves, the history of your company, the history of your officers. These rules and regulations and the disclosure requirements, which again we'll get into, are really mandating that you receive this information so you can make an informed decision as to whether or not the investment opportunity is something that you're really interested in. It's really trying to mitigate some risk. Okay? Now, while the federal security requirements in the Rule 504 is limited, the state blue sky laws often impose more detailed requirements on these very small offerings, and they are governed by federal anti-fraud provisions and civil liability provisions under the Exchange Act. Exchange Act is one of the other security acts within the United States that govern these issues. I think my colleague is going to go through some of the blue sky laws and give us some guidelines on that and some insight on enforcement issues if someone someone steps outside of the regular outside of the provisions that are mandated. So. The next rule is 505, and Rule 505 governs offerings of no more than $5 million of securities in any consecutive 12-month period. Now, unlike the offerings under Rule 504, 505 imposes a limitation of sales to only 35 what are called non-accredited investors, while allowing sales to an unlimited number of accredited investors. Now, I'll get into that and I'll define those a little more generally in a couple minutes, but really think about when you're talking about an accredited investor, it's someone who has a particular net worth and it's presumed to have the ability to fend for themselves. They're presumed to have a level of knowledge and sophistication about particular investments such that the standard of information and the risk of them being deceived is not as great. Okay? So, under Rule 505, general solicitation or general advertising, like taking out an ad in a newspaper or inviting people out, or generally inviting people to invest, is not permitted, and such security is not allowed to be resold. So the example that Johannes was talking about, flyers indicating that there's a great investment opportunity and you should come and invest your money, that's bargain, in short. And really what the gist of the matter is that you have to have a pre-existing relationship with these people. You have to have some idea of who you're dealing with. And if you can prove that, then you're in better shape as far as being able to say you've complied with the law. And clearly ads are not the way to go. So, while there are 2 other rules controlling offerings within certain ranges, Rule 506, this is the last rule that I'll go over, has no particular dollar limitation to it. Now, again, unlike offerings under Rule 504, Rule 506 imposes a limitation of sales to only 35 non-accredited investors while allowing sales to an unlimited number of accredited investors. Again, you can see that the gist here is trying to control the offering and sales of particular opportunities, so that it's not a general solicitation to the general public. And ideally, it's people that you know that you're dealing with that can have some greater insight as to what the opportunity is and get the relevant information they need to make the relevant investment. Okay, so going on, Rule 506 goes a step further than the 505. And basically, at the time of the purchase, each non-accredited investor, again, that's the person who doesn't meet that particular standard that we'll talk about of sophistication and whatnot. At the time of the purchase, each non-accredited purchaser must itself meet certain sophistication standard. And again, this is not a legally defined term, but generally means that the purchaser has reasonable investment experience and knowledge in light of the purchase. So even under the standard where you're deemed not to be an accredited investor, you still have to be reasonably sophisticated about the purchases and of securities out in the marketplace. Again, Rule 506 prohibits any form of general solicitation or advertising. Now, here's what I was talking about with respect to the accredited investors. Now, if you have the option, one should really limit your solicitations to strictly accredited investors. Again, these are people who have a certain net worth or a certain income level, and the thought is that they have a certain sophistication level and they'll have the ability to ask the relevant questions to protect themselves from any particular scam. And if you're the person who's actually making these particular offers, it really behooves you to really deal with accredited investors, because it's further protection that you're not going to inadvertently sell to someone who may have a claim against you because they did not meet particular standards of sophistication. But in talking about accredited investors, there's really four main categories that we're talking about. First category, directors, executive officers, and general partners of the offeror. Now, you really have to think, if anyone's going to have information about what this particular opportunity is and its relevance, and it's going to be these people who are directly involved in the business, such as these particular executives. And so they are deemed to be accredited investors and people who are really in the category of these prime people that you want to sell to. Again, going on, purchasers with a net worth, whether either as an individual or jointly with his or spouse, equal to or greater than $1 million. Again, it's the level of sophistication I was mentioning before. Then going on, a natural person. By natural person, we typically mean someone that's not a corporation, because a corporation is its own entity, but we're just talking about you and I. Can also qualify as an accredited investor based on a certain level of income, which is specified there. And in certain businesses, a business entity can be treated as a single accredited investor. Looking through, you have to count each owner separately for the purposes of offering. Little legalese, but I won't bore you with that. But really, when you're talking about a private placement, I just want to briefly go over a couple of the documents. The real thing that you're talking about is the private placement memorandum, which is generally known as the PPM. Now again, it provides a lot of the details that you need to know and that you would want to know as an investor to make sure you're making a really informed decision and this is the right opportunity for you. There's information about the company, the proposed company operations, the transaction structure, whether you're selling equity ownership or raising debt financing from the investors, the terms of the investment, what is the share price, the note amounts, the maturity dates, and what are the risks that the investor may face. There are risks in just about every investment, and you want to have an honest assessment from the person who is selling, or from the person you're selling to. You want to tell them what exactly could go wrong, so that if anything does go wrong, at least there's the ability to say, "I told you so." Okay. And then oftentimes in the PPM, you'll come across something called the subscription agreement. It really sets forth the terms and conditions of the investment, and really it acts as the sales contract for purchasing securities. And one of the things that you'll see in there, there'll be things called representations, which basically say that you are an accredited investor, or you're permitted to make these particular purchases, and those are particularly relevant provisions that you should review with your counsel to make sure you understand, and don't get yourself in any hot water. So that's my general overview, and happy to answer any questions.